Carrying on, Rule 15, depositions. Rule 15, depositions. So here's another rule that Michael Gonzalez doesn't seem to understand. I said, to save the court some time, let's get these depositions. But he was like, no, we don't want to save the court time. And actually, fuck you. Only I get to understand the law here. I'm the judge, and it doesn't matter if I cheat you. I asked him if he was, if he was prejudiced, and he seemed to, take a step back. Because I think he is, but he didn't want to say that he is. Of course he is. He's a rubber stamper. He's a rubber stamper for the fascist. Hey, what, some fascist said that you did? Well, if a fascist said you did something, motherfucker, you cannot hit a person 300 times, and if that person goes to defend themselves one time, you better not hit me again. Hey, that's felony menacing. You can't do that to a person. That's fucking bullshit. That is bullshit. Motion in order. The prosecutor or the defendant may file a motion supported by an affidavit anytime after an indictment, information, complaint, or summons in complaint is filed requesting that the deposition of a prospective witness be taken before the court. Here, listen, Michael Gonzalez. This is Rule 15. This is about the depositions. This is what I believe the law is when it comes to depositions. You might have a different interpretation, no doubt, but this is what I believe that the rule for, depositions. It's Rule 15 from CRCP. I wonder where the hell he's getting his. So the court may order that a deposition be taken before the court if a prospective witness may be unable to attend a trial or hearing, and it is necessary to take that person's deposition to prevent injustice. Yeah, you would want all the eyewitnesses at the very least, right? You would want all the eyewitnesses. Them motherfuckers need to come out and, what's going on? Let's get your testimony. Come on, come to court. Let's hear your all's testimony. At the very least, right? All the eyewitnesses at the very least. Also, all the character witnesses, all the ones. Yeah, no, I mean, if anything, you live in a neighborhood, wouldn't you be, at least this is the way I am, because I'm proud to live in a republic. I'm proud to live in a civilized republic. If I'm called up for jury duty, if somebody wants me to testify, I got some, I would be happy. I'd be happy. What, you want me to tell you how the neighborhood is? You want to know my opinion about this and that? I would be happy to go to court to tell you what's going on. That's our system, right? That's our system. So, yeah, I mean, that's, if we care about the community and everybody, I would think everybody would want to, there's some shit that's been going down. It's bullshit. Let's all go out here. And that's if we care about, civilization, civil society, freedom, love, justice, solidarity, peace. That's if we care about, that's if we have any virtues whatsoever. Do we have any virtues left? Did you all have any virtues to begin with? The court shall identify the witness and fix the date and time for the deposition in the order, and shall give every party reasonable notice of the time and place for taking the deposition. For good cause shown, the court may reschedule the date and time for the deposition. A.5. Deposition by stipulation permitted. The prosecution and defense may take a deposition before a judge by stipulation. B. Subpoena of witness. Upon entering an order for the taking of a deposition, the court shall direct that a subpoena issue for each person named in the order, and may require that any designated books, papers, documents, photographs, or other tangible objects not privileged be produced at the deposition. If it appears, however, that the witness will disregard a subpoena, the court may direct the sheriff to produce the prospective witness in court, where the witness may be released upon personal recognizance or upon reasonable bail, conditioned upon the witness's appearance at the time and place fixed for the taking of the deposition. If the witness fails to give bail, the court shall remand him to custody until the deposition can be taken, but in no event for longer than 48 hours. If the deposition be not taken within 48 hours, the witness shall be discharged. So yeah, to preserve all that evidence, I mean, you had about 6 or 7 eyewitnesses so that means all those eyewitnesses need to show up. The state, they listed 5 witnesses. So their witnesses need to show up, and then anybody else that they might add to the damn list, they need to show up. I mean, you could have just got depositions, right? Saved everybody time. But all right, let's not who gives a shit about due process? Am I right, Michael Gonzalez? He don't give a shit about due process. He don't know shit about due process. He gives protection for the criminals nonstop. Dozens and dozens of crimes have happened to me, and he's given protection to them. I mean, Kenny Capin, is Kenny Capin like the Abraham Lincoln of goddamn Christian? I bet he ain't fucking shit. I bet he's a piece of shit, a loud ass motherfucking greedy piece of shit. I bet he's a fucking sick, evil, wicked, criminal piece of shit. But that's who Michael Gonzalez protects. And other felons. That's not just Kenny Capin. Robert Pickrell. He protects Robert Pickrell. If it appears, however, that the witness will disregard a subpoena, the court may direct the sheriff to produce the prospective witness in court, where the witness may be released upon personal recognizance or upon reasonable bail, conditioned upon the witness's appearance at the time and place fixed for the taking of deposition. If the witness fails to give bail, the court shall remand him to custody until the deposition can be taken, but in no event for longer than 48 hours. If the deposition is not taken within 48 hours, the witness shall be discharged. C. Presence of defendant. The defendant shall be present at the deposition unless the defendant voluntarily fails to appear after receiving notice of the day, time, and place of the deposition. D. Taken and preserving depositions. Depositions shall be taken as directed by the court. All depositions shall be preserved by video recording at the expense of the requesting party. A copy of the video recording shall be filed with the clerk of the court and provided to the opposing party. E. Use at the trial or at any hearing, a part or all of a deposition may be used so far as otherwise allowed by law or by stipulation. F. Transcripts of depositions. The requesting party shall file a transcript of the deposition with the clerk of the court and provide a copy to the opposing party without cost. CRCP 15. CRCP 15. Coming up next, Rule 16, discovery and procedure before trial. My God, this is 1, 2, 3, 4, 5 pages. 6, 7. Discovery goes on and on and on and on. 8, 9, 10. God damn. So Rule 16 is a doozy. There's about 10 pages for Rule 16. And then Rule 17 right after that for subpoena. Discovery and procedure before trial. Woo! I wonder what that's about.